thanks to all the panelists. I think that we have really done a deep dive and set the stage for how and why we've gotten to this point in time. And so what I want to do now is have the panelists talk about, so where do we go from here? What are possible solutions to the impasse, to some of the specific problems that have been identified as, whether it's the United States that's identified those problems or other larger problems. So let me start with Jennifer, and I know you've done a lot of writing and thinking about this issue. So, let's hear what you think can be done or should be done, and then we'll, the other panelists as well, we'll follow on from there.
Well, thanks. Some of you may know, maybe I'm on a song theme here this morning, but I put out a paper about a year and a half ago called The Good, the Bad, and the Ugly. Maybe that's a film reference rather than song, but nonetheless. So my idea behind a good proposal would be to acknowledge that the vast majority of the substantive complaints that the United States has are about decisions in the trade remedy area. So the argument in this paper was maybe we consider treating trade remedy decisions differently at the WTO, either by creating a specialized appellate body that would have particular trade remedy expertise, or possibly by saying you don't even need an appeal from a trade remedy decision, because the panel itself is acting much more like an appellate reviewer when it comes to trade remedy cases, because across the world, anyone that imposes an anti-dumping, countervailing duty, or safeguard has to have had an underlying investigation where their domestic authority already decided the facts and the law, and so a panel already sits somewhat in an appellate role in any event. So that was my sort of good proposal. My bad, fairness, was the Article 25 arbitration process that Canada is proposing. I will say at the time that I wrote this, part of the reason why I described it as bad is because I thought that by providing this kind of an alternative, you were going to be taking the pressure off of trying to fix the appellate body, which I still think is a better goal. And my ugly was that you would use the system within the WTO to go to voting, to vote on members of the appellate body. I have evolved a lot in my thinking as I've done this. And so I have now come to the view that I think there is a much better plan out there, a much better system that we could engage in to fix the appellate body. And so here it is. It's three basic elements. I think one of the first things I think needs to change in Geneva is the staffing and the secretariat at the appellate body. Because I do think that the fact that the appellate body secretariat, and particularly, the lawyers that are there have stayed as long as they have, is part and parcel of this kind of ossification, where the decisions become very much sort of wedded. I mean, and that the role of the secretariat over time has increased and increased and increased, because you now have members of the secretariat that are staying twice as long as an average appellate body member. Again, the appellate body members work on a part-time basis. They're there for 4 years, potentially reappointed to another 4, so a total of 8 years. And yet you have secretariat staff that are there, 10, 20, 30, whatever. I mean, long periods of time. So my first idea is to create a term limit or a mobility principle for the lawyers that work at the appellate body secretariat, to say basically you cannot stay longer than the members of the appellate body. And the idea there is really to try to restore some balance between the power that the appellate body members themselves have and the power that the secretariat has. And also, I hope to move away from this ossification of the decisions, where everyone becomes wedded to the words that they wrote in the last opinion, and so lo and behold, those same words start coming into the next opinion. So step one, create some real fresh thinking and some real mobility within the secretariat. The second thing to me is that you must adopt these Walker principles. And again, I will pick a little bit with Terry, because I think the Walker principles do try to address very clearly each one of the very specific complaints that the United States has had. I mean, they say, again, that appellate body members cannot stay on beyond their term. So that if you only have 60 days or less on your term, you cannot be assigned to a new appeal. So you don't have the option of staying over, because you wouldn't be assigned to an appeal in the first place. On the 90 days, I mean, just flat out saying the appellate body is obligated to issue its report in 90 days. And that you cannot exceed the 90 days unless you have, the views of the parties. I mean, making it very clear that municipal law is a matter of fact, not subject to appeal. That you cannot treat facts as legal questions through this use that has been come up very, very strongly over years of what is referred to as Article 11. I mean, you cannot go down that road. That the advisory opinions, again, that the appellate body shall address issues raised by the parties only to the extent necessary to assist the DSB in making its recommendations. So again, the Walker Principle very clearly addressing the United States' concerns that they don't want advisory opinions. The Walker Principle is on precedent. Precedent is not created through WTO dispute settlement proceedings. I mean, just unequivocally not created. You know, and saying that, again, that to the extent that there is a panel or appellate body report out there, it should be taken into account only to the extent that it is relevant to the dispute before them. So again, it is not binding precedent. It's making it very clear, you know, sort of on overreach, making it very clear that the DSB cannot add to or diminish the rights, and trying again to lift up these particular standard of review that exists in the anti-dumping agreement, second sentence of Article 17.6.2. So again, I think across the board, these Walker Principles are trying to address the concerns that have been expressed by the United States. So step 2 in my 3-part plan of how do we fix this is adopt these Walker Principles. And then clearly as part of that adoption, I do think there has to be this kind of recognition that all of the members, including the European Union and others, that the United States has some skepticism about, agree that these Walker Principles are necessary and needed to course correct for where the appellate body is now, to bring the appellate body back on track. And I think if you got that kind of clear statement out of the members, including those that the United States regards as skeptical, I think, again, it would go a long way to saying we are all in this together, we are all about a reform. The third part of my element is, I think, addressing some of what we've heard here, which is a need for some increased political oversight over the appellate body. I think there's no question that that's sort of the theme that is coming through to this. So my own view is you could set up a commission. Again, my own sense is I think it would work if you included the heads of the key committees of the WTO, the chairs of the General Counsel, the Dispute Settlement Body, the Council on Trade and Goods, the Council on Trade and Trips, Trade and Services and TRIPS, and then added in some independent international trade law experts. And what would this commission do? To me, its role would be a couple things. One, to conduct an audit on an annual or semi-annual basis. Did the appellate body adhere to the Walker Principles? Literally go through decision by decision and look, did you agree, did you adhere to these Walker Principles? Because I do think if there were some kind of an audit that suggested that the appellate body had not done so, I think there would be a huge kind of naming and shaming factor vis-a-vis the appellate body. But then secondly, allow this appellate body, this commission that I'm talking about, to function almost like the Extraordinary Challenge Committee that we have in the NAFTA, or potentially an annulment process that you might have in investor-state dispute settlement, where if there was a particular case in which it was very clear to the parties involved that there had not been adherence to the Walker Principles, that you could again then invoke this commission to say, you know, do you find that the appellate body did in fact adhere to these Walker Principles or not? So again, I think you could create a way to create oversight and enforcement of these Walker Principles that would address what the United States is saying about the Walker Principles. Because fundamentally what the United States is saying is not particular objections to each one of the individual Walker Principles. The principal objection that you hear in Geneva is they're just words on a page. The words were already on the page that said that the appellate body would do its decisions in 90 days. Since it hasn't agreed to that rule, why would they agree to the Walker Principles? So the idea is that you would try to bring in the notion of a way to hold the appellate body to those Walker Principles as another sort of, as the third element of what I think would represent a genuine package of reform that would genuinely address the concerns that the United States has done and would create this kind of course correction at the appellate body that would bring us back to kind of where we were in the beginning of the system.
I think Jennifer and I are in agreement that you need more than words on a page to get the United States to agree that there's a solution that's there. What the specifics are, obviously, one can debate. I strongly agree that there are problems with the tenure of the appellate body secretariat. I think that is a contributing factor, so I think that that's an excellent suggestion that should be done. I do think that the U.S. has objections on some of the Walker principles that do not actually address in totality their concern. And I would say the tenure of members after the term has expired is one. I think that can be handled with a change in terms of the number of days. Jennifer did not mention at all anything on overreach as far as it pertains to dealing with the past. Right? If you look at the number of decisions, the number of countries who have been concerned enough to raise at a DSB meeting that the appellate body has engaged in overreach, it is roughly, I think, 1 in 3 or 1 in 4 cases where there has been some issue that has been problematic for one of the parties to the proceeding. I don't think you get to a resolution of this issue without having some mechanism in place to permit a reevaluation. I think the only area in the Walker principles that don't work in terms of if you had enforceability is the 3.2.19.2. What does it mean not to create rights or obligations? Right? That language has been there since the beginning, and the concern is Europe has always referred to the second sentence, which talks about the interpretation according to international law. The U.S. has always focused on that sentence. And the real question is does filling gaps constitute creating rights or obligations? If you don't get to a clarification of that issue, then regardless of what you put in, you are not going to solve the concern the United States has with overreach.
Thanks, and I agree with both Jennifer and Terry that it's really a combination of approaches that are going to be necessary here. There are going to be some that are institutional, but there is going to be a need for more guidance. And as for whether the principles that Ambassador Walker has already included in his decision go far enough, I think that that process has been handicapped by the fact that the U.S. has not provided more specifics on how these responses can be addressed. But that process has made really moved the ball forward really a great deal, because even in reaffirming some of the original commitments in the DSU, whether it's 90 days or not adding to or diminishing rights and obligations, you do have a large number of members who are participating in this process, who are core users of the process, who are essentially agreeing with the United States that these were concerns. So I wouldn't underestimate the progress that has been achieved in that group. But having said that, the principles, as they currently are set forth, are to the large extent just reaffirmations. And as the U.S. has expressed the concern, if they're just reaffirmations, how do we know that the appellate body is going to follow it this time around? That's one of the reasons why they do want this acknowledgement that something has gone wrong. But I think, as Terry has pointed out, if you do elaborate in relevant part some of those principles, you can actually go a long way. When the dispute settlement understanding was drafted, members didn't contemplate these problems arising. They didn't draft to try to address these problems because they didn't know they were going to come up. Well, we do have a record now. We do know what the problems are, and there can be more specific drafting. So just to give one example, in the Walker Principles, it reaffirms or affirms that there shouldn't be advisory opinions, and it says that the appellate body shouldn't be addressing issues that members aren't raising on appeal. Well, that's good as far as it goes, but it's also the responsibility of the appellate body to reject arguments that are made by parties if, for example, they're not in the terms of reference of the dispute. The advisory opinions are often given with regard to legal provisions that aren't even at issue in the dispute. And so whether that's come up because of the appellate body's own interest in the topic or because a member has raised it, at least cover in these elaborations in this guidance that's being provided through the Walker process, some of those specifics. And I just wanted to also just mention that, Marvin mentioned that the importance of restraint on the part of members as one of the solutions here. And I don't disagree, and this is also reflected in part in the Walker principles themselves, this need for restraint. And I don't disagree that that would be a great thing if members were to consider their systemic concerns and interests in a way that did lead to this restraint. But ultimately, where the restraint needs to be exercised is with the panels and with the appellate body, recognizing that there's an effort to push the envelope on their argumentation, and that's going to be inevitable with lawyers involved, with litigators involved. So it really is incumbent upon the adjudicators themselves to appreciate their limits, and quite frankly, had the appellate body been quicker to reject some aggressive arguments early on, you wouldn't have seen as many appeals as you have right now. So that perhaps also needs to be included in the guidance. This notion in connection with what it means to be adding to or diminishing rights and obligations, what it means to be Catholic, that can help provide the basis for the appellate body to say, okay, we're not going to go there.
Marvin, did you want to comment?
I think, in all of this, it'll be important to keep various things in context, and certain, the relative importance. The 90-day rule, yes, it would be good to have things done within 60 or 90 days, but again, the volume of work was never quite anticipated on a number of part-time appellate body judges that exist today. And also, in terms of the perfect not being the enemy of the good going forward as these things do get resolved. Yes, there's history. There's almost 25 years of history, and there's also the future, and there's the way we want things to work going forward. If we look back at the perceived deficiencies, various members, including the U.S., have the things that they have concerns about. Those things have also benefited them in other cases or in other sectors, right? And so many members, have it's cut both ways, in different cases and in different sectors over time. And I'm not sure exactly, the balance between looking back and fixing every mistake in the past or every perceived mistake versus setting the stage for a productive way forward.
Thank you very much. To our panelists, I think I'm going to open up the floor for questions. I know Ken would say this as well. Please make it a question and try and keep it brief, because I imagine we'll have a number of questions.
And please identify yourself and